Who can apply for probate in Arizona? Hi, I'm Attorney Paul Deloughery. The probate process ensures that a person's assets are properly distributed after they pass away. But the process can be complicated, and understanding who can initiate it is crucial. So let's break it down. First, let's talk about the difference between informal and formal probate, because it's important. So informal probate means that the initial probate documents are filed with the court, and the personal representative can be appointed without the need for a hearing. So it doesn't actually go in front of a judge. Now, if you can't file informally, then it has to be done formally. And that means that there has to be a hearing scheduled, and a probate commissioner or judge will rule on whether to grant the request in the petition, meaning to admit the will and appoint a personal representative. Okay, under ARS, that's the Arizona Revised Statute 143301, certain people have the right to file an application for informal probate. The statute provides as follows: informal probate or informal appointment of a personal representative may be made only by application of one of the following: the surviving spouse of the decedent, an adult child, a parent, a brother, or a sister of the decedent, a person who is an heir of the decedent, meaning probably someone other than those people I just named, a person nominated as personal representative by a probated will, or the will for which probate is asked, or pursuant to a power conferred by a will. Okay, a lot of words. Anyway, according to a will, that's what it means. And then fifth, if the decedent was not a resident of the state, any person who is qualified under the previous paragraphs. Okay, or a personal representative appointed in another state. And then sixth, if the decedent was a veteran, then the Department of Veteran Services can apply. 45 days after the death of the decedent, any creditor can apply. And then eighth, if no person is qualified, if none of the other people we just named is qualified or willing to serve, then the public fiduciary can apply. And that's an entity that is appointed by, here in Arizona, each county has a public fiduciary. Okay, but what if there's a disagreement or some complication? Well, in that case, the probate probably needs to be done formally, meaning there needs to be a hearing. Now, a formal petition can be filed by any interested person, and it doesn't really define, the statute doesn't really define what that means. Certainly, any of the people that I named previously, an heir, a relative, whatnot, a beneficiary, someone named in the will. Anyway, interested person's not really defined, so it's a little broader. Now, in the event of a dispute, or if informal probate is not suitable for some reason, then interested persons can file a petition for a formal appointment of a personal representative. Okay, now let me talk again about what interested persons mean. It can include heirs, devisees, meaning people who are supposed to get things in the will, children, spouses, creditors, and others holding a property right or a claim against the estate. That's probably a creditor, but okay. And then, so essentially, those with a stake in the proceedings can apply for a formal appointment. Now, it's worth noting that not everyone has the same level of influence in the appointment. According to ARS, again the statute, 143203, there's a pecking order for who has priority for appointment as personal representative. First of all, the person with priority is the one named in the will to act as personal representative. Okay. Next in line, surviving spouses. Well, I should say, because we're dealing with a deceased person, so the surviving spouse, who's also a devotee or beneficiary under the will. Then other devotees, other people named in the will to receive stuff. Okay? And then fourth, the surviving spouse of the deceased person. Fifth, other heirs. Now, heirs are people who are supposed to receive things if there's no will. Okay, that's what an heir is. Sixth, if the deceased person was a veteran, then again it's the Department of Veteran Services. Seventh, 45 days after the death of the decedent, any creditor can apply, but there's an exception for funeral homes and whatnot. Anyway, and then finally, the public fiduciary can apply. So it's a structured process that's supposed to ensure that the deceased person's wishes and the interests of all parties are considered and protected. So, to quickly summarize, possession of the will allows for the application of informal probate, and specifically if you have the original will. If you have only a photocopy, then you can't do it informally. Next, interested persons can petition for formal appointment of a personal representative, and there's a set priority for appointment of personal representative, and it's set out in the statute. Okay, so I know that's a lot to take in, but understanding these facets of Arizona probate law can ensure that you're equipped and informed. So whether you're navigating the process now or preparing for the future, we're certainly here to help. And if you found this video helpful, please give us a like and share it and subscribe for more legal insights. And also, if you have a question about probate, just give us a call at 602-443-4888.